May I recognize the following dignitaries who have graced this occasion: the Acting President, Vice President and Minister of Justice, Legal and Parliamentary Affairs, the Honorable E.D. Nagaga, the Minister in the Vice President's Office, the Honorable C.C. Sibanda, the Minister of Provincial Affairs for the Harare Province, the Honorable Miriam Chukwuka, the Justice Makarao, the Acting Secretary for the Judicial Service Commission and Guardian of the Constitutional Court, the Prosecutor General, Mr. J. Tomana, judges of the High Court, Administrative Courts and Labor Court, Deputy Attorneys General here present, and the Deputy Prosecutor General, Secretary for Justice, Legal and Parliamentary Affairs, Mrs. V. Magdiza, His Worship, the Mayor of Harare, Engineer B. Manyingini, Chairperson of the Human Rights Commission, Mr. E. Mugwadi, the Deputy Chairperson of the Law Development Commission, Mr. B. Zoa, Commissioners of the Judicial Service Commission, Deputy Commissioner Matibiri and Deputy Commissioner Shambari of the Zimbabwe Republic Police, Deputy Commissioner General of Prisons and Correctional Service, Deans of the law faculties at the universities of Zimbabwe, Midland State and Great Zimbabwe, the Principal of the Zimbabwe Judicial College, Mr. Shan, the Chief Magistrate, Mr. Guamonde, and all magistrates here present, and the President of the Law Society, Mrs. V. Niemba, and members of the profession here present, members of the media fraternity here present, ladies and gentlemen. Today marks the official opening of the 2016 legal year. I wish to take this opportunity to thank all of you who have gathered here today to witness the occasion. Before I proceed much further with my address, allow me, distinguished guests, ladies and gentlemen, on behalf of the judiciary, the Judicial Service Commission, and indeed on my own behalf, to congratulate Advocate Prince Machada on his appointment in February 2015 as the Attorney General for Zimbabwe. We in the Judiciary and Judicial Service believe that this was an appointment that was well made and well deserved. We wish you well, Mr. Attorney, in your new office, and pledge our reserved support as we all strive to uphold our Constitution and to enhance effective justice delivery in our courts. I also wish to take this opportunity to thank all the key players in the justice delivery sector for a very congenial and fruitful 2015. We enjoyed cordial relationships and close collaboration with all the key players in the sector, and it is my fervent hope that this close cooperation will be the mark of all our relationship henceforth. I note with some degree of satisfaction that all the key players are represented at this gathering, and again symbolizing our unity in justice delivery. Mr. Attorney, all the key players in the justice delivery system are autonomous entities who are not subject to the control of any person or authority in the discharge of their respective mandates. Our respective independence and statutory autonomy should, however, not stand in the way of close collaboration and cooperation within the sector. I believe that there is a wide scope for greater collaboration within the sector. After all, our independent efforts and operations which converge at the courts are intended to enhance effective justice delivery. It therefore makes sense that we must voluntarily come together more often than not to compare notes and to coordinate our efforts. Allow me then, Mr. Attorney, to say a few words on each of the key players in the justice delivery sector and on how their functions impact on the operation of the courts, or impacted on the operations of the courts in 2015. The Zimbabwe Republic Police. The Zimbabwe Republic Police interface between the Zimbabwe Republic Police and the judiciary is an indirect one. After making an arrest, the police submit the docket of the case to the office of the Prosecutor General, where in some instances, some of the investigated cases may fall off. It is only those cases that the Office of the Prosecutor General refers to the court that we in the judiciary can account for. The dockets that are ready for prosecution but have not yet been presented to the court may be, but do not constitute the backlog that we annually report on. In my view, they should. In real terms, there should be a correlation between the number of arrests made by the police and the workload of the criminal courts. It is this direct correlation that informed our realization that the High Court circuit are not clearing the backlog of all the cases that the police are bringing to the court through the Office of the Prosecutor General. Mr. Attorney, you may have read in the press about my recent visit to Masvingo to assess the viability of setting up a permanent High Court in that city. That visit and the strategy informing the decentralization of the High Court to other provincial capital was prompted by the realization that the number of arrests by the police in the provinces is by far exceeding the rate at which the circuit courts are clearing cases emanating from those provinces. Allow me again, Mr. Attorney, to make just one point regarding the relationship between the police and the judiciary. There is need for greater sharing of statistics in matters of crime and prevalence of crimes to enable the judiciary to respond effectively by establishing enough force to match the efficacy of the police in effecting arrests and investigating crimes. Currently, there is no requirement for the police to inform the judiciary of the number of arrests that they make over any given period. There is no requirement for the police to inform the judiciary of the backlog of cases that the police at any given time. There is no common tracking system to establish where in the system, if any, report to the police by the citizen is delayed even after the accused person has been formally remanded by the court. Later on in my address, I shall refer to the performance of the Magistrates' Court. Statistics that I refer to in that part of my address reflect the cases disposed of by the courts. The figures do not reflect the cases that the police have completed investigating and are now awaiting trial. I'm not privy to those figures. I now turn to the prison and correctional services. Mr. Attorney, the relationship between the judiciary and the prison and the correctional services is a direct one. The department's services courts directly, and no criminal court can sit without a prison officer in attendance. I'm happy to report that during the course of the year, there were very few reports of the department failing to service the courts for want of fuel. I wish to commend the department for a successful 2015 in servicing the needs of all courts countrywide efficiently. The offices of the Attorney General and the Prosecutor General and the Law Society and the legal aid providers. The legal representation in any court, be it criminal or civil, invariably is by one or more lawyers from these offices and organizations. In another forum, I have had occasion to express my views on the standard of legal representation in this country. I find it a mixed bag. Some practitioners are very good and assist the court in quickly concluding matters before the court. We in the Constitutional and Supreme Courts have found as a general rule that advocates from the sidebar are better prepared and much assistance to the court. On the basis of such observations, we have opened debates with the Law Society over the issue of whether or not the profession should remain fused or should be separated into advocates and attorneys. I wish to take this opportunity to extend my gratitude to members of the Law Society who, upon request from the court, have offered their services as amici curiae in a number of cases. As I stated earlier on, 2015 has witnessed the coming together of the key players in the justice delivery system sector in a commendable way. I can only urge all of you to continue realizing that working together, our collective institutional capacity is enhanced and we are able to deliver justice more expeditiously and effectively. I also wish to commend our lessons joint effort in coming together as a sector to collectively condemn corruption within the sector. I am aware that during the course of 2015, a number of meetings were held to strategize on how to combat corruption within the sector. It is up to us to not only combat corruption within our sector, but also to lead by example. Let us continue to double our efforts at combating corruption. Before I address you on the performance of the courts, Mr. Attorney, allow me to note with profound sadness the passing on during the course of 2015 of the Honorable Mr. Justice Andrew Montaigne, for whom we convened a special sitting of court. I also wish to mention with sadness the passing on of the acting registrar of the Administrative Mrs. Daisy Tungwakwa, and four other members of the Judicial Service Commission who were serving in various magistrates' courts throughout the country. May their dear souls rest in eternal peace. And now turning to the performance of the courts during the 2015. Before I proceed to detail the performance of this court, dealing first with the Constitutional Court, before I proceed to detail the performance of this court over the preceding year, allow me, Mr. Attorney, to congratulate Justices Mavangira, Justice Gunu, and Justice Uchena on their appointment to the Supreme Court, which also doubles as the Constitutional Court. To the judges, I say your hard work in the High Court and your performance at the interviews held in public in June 2014 resulted in your recognition and elevation to the highest court in the land. May your appointment serve as an impetus to those in the High Court and indeed to those within the entire judicial service to be diligent in their duties for future recognition. Seniority alone is no longer the only consideration for the elevation within the judiciary. Performance is now also an important factor to be taken into account for promotion. The number of cases filed in this court, Mr. Attorney, continues to increase steadily. In 2013, the year in which the court was inaugurated, 81 cases were filed with the court. In 2014, a total of 79 constitutional applications were filed. In 2015, a total of 101 applications were filed. This is a 28% increase. In marking the opening of the 2015 legal year, I commended the judges of the Supreme Court, who also act as judges of the Constitutional Court, for a job well done. I wish to commend them once again for rising to the occasion in 2015. Whereas they completed 52 constitutional applications in 2014, in 2015 they managed to clear 78 cases. Again, I mentioned that this feat was achieved in addition to and notwithstanding their additional workload in the Supreme Court. The figures that I have just given out, however, are a cause for concern. Whilst the judges of the Constitutional Court are working as hard as they can, the inflow of work into that court continues to outpace their best efforts. Over the past 3 years, the court has accumulated a small but growing backlog, which now stands at 146 applications. If one considers that at best the Supreme Court can clear 80 cases per year, we need more than 1.5 years just to clear the backlog that has accumulated to date. We must therefore all double our efforts to ensure that this backlog does not become debilitating in the long run. On our part, we have flagged the need for the physical separation of the Constitutional Court from the Supreme Court. With the Constitutional Court judges dedicated to constitutional matters only, we believe that the backlog may be arrested. Turning to the Supreme Court, the number of appeals filed in the Supreme Court grew by 38% between 2014 and 2015, whereas 481 appeals were filed with the court in 2014. A total of 646 appeals were filed in 2015. The Supreme Court judges completed a record 610 cases in 2015 compared to 333 cases in 2014. I wish to commend them for this 83% increase in their output. Whilst the Supreme Court managed to complete a record 610 cases, the court issued 81 written judgments during the course of the year. This roughly translates to one judgment for every 7 cases completed. I am aware that there is concern mainly from the legal profession on the relatively few judgments coming from the Supreme Court and the fact that most cases are disposed of on the basis of court orders. Whilst not downplaying the need for the Supreme Court to always give detailed reasons for their decision, I clearly understand the predicament that the court finds itself in. It can issue more written judgments and thereby dispose of less cases. Or alternatively, it can continue to endeavor to carefully select those instances where a written judgment is imperative and those where the law is settled and an external judgment will suffice. Again, in my view, the situation can only be corrected by the physical separation of the Constitutional Court from the Supreme Court. Before that happens, it will be too onerous an expectation for the Supreme Court judges to complete many cases and write many judgments, as well as discharge their Constitutional Court mandates concurrently. One of the desired results must yield. Mr. Attorney, I now turn to the High Court. On the same day that I swore in 3 judges into the Supreme Court, I also swore into office 6 new High Court judges. These 6 judges were also selected as the best performers after interviews held in public in November 2014. The 6 justices are Justices Koroma, Charewa, Piri, Chitapi, Mushore, Mnangati, Nongwa. The Judge President advises me that you have hit the ground running. I say well done and welcome to the High Court. Your appointment seems to have coincided with renewed vigor in that court, that is the High Court. For during the year of 2015, a record of 1,237 judgments were handed down by that court alone. This is a significant improvement on the previous year. Mr. Attorney, you will recall that at the official opening of the 2015 legal year, I referred to what I termed unacceptably low performance by some judges of that court. I'm happy to report that the performance of the High Court this year has exceeded my expectations, and I wish to heartily congratulate judges of that court for the pleasing performance as evidenced by the number of judgments that they have returned during the course of the year. The number of judgments handed down has in turn drastically reduced the number of complaints that I used to receive over delayed judgments. Let us accept let us all accept that this is the normative standard of an effective justice delivery system. I regret, however, to say, Mr. Attorney, that as is to be found in any functional system, there are still a few judges in the High Court who may still need to introspect in the light of the high performance by their colleagues generally. Whilst the judges have been doing their best to clear the cases that are filed with the High Court registry, my attention has been brought to a number of files that are dormant or semi-dormant in the High Court. In a report to me, the Registrar of the High Court has indicated that there are more than 40,000 records that have been dormant for 3 or more years. These are matters that were filed as far away back as 2002 up to 2012, but are lying idle with no one prosecuting the claim or applying for the matters to be dismissed. 20,000 of these records are summons of applications that have not been served on the defendants or respondents. Some people may not know that they've been sued and are part of the High Court statistics even as I speak. As we seek to amend the rules of the courts to deal with this problem, I wish to invite members of the profession and the litigating public to take note of this undesirable state of affairs and to assist us to come up with rules of court that will lapse such processes automatically if they are not prosecuted within a reasonable period after filing with the court. Currently, there are no such rules. On yet another positive note, the High Court marked a drop in the backlog of cases pending before that court. Whereas at the beginning of 2015, the High Court had a backlog of more than 1,002 action matters. It closed the year with a reduced backlog of 504 cases. This translates to a 50% reduction in the backlog, and this is a remarkable feat by all standards. I am not quite clear on why this trend was not maintained in respect of application matters, where there was a rise in the backlog from 2,796 at the beginning of the year to 3,578 at the close of the year. Application procedure is expected to be more expeditious than action procedure. I urge the Brigade President to look into the matter with a view to addressing the situation. Mr. Attorney, again a pleasing result was posted in the Criminal Division of the High Court, where the court opened with a total of 2,991 cases and closed with 2,836 cases. This was after it received 8,047 fresh cases for that year. Thus, all in all, the court completed a total of 8,217 criminal matters. The court has also managed to reduce the backlog of appeals from magistrates' courts. At the beginning of the year, the court had 5,487 appeals pending. It then received a further 1,756 appeals during the course of the year to make a total of 8,284. Of these, 5,034 appeals, leaving the backlog at 2,288. This is a small backlog that can be cleared in 1 year if all records of appeal are prepared and forwarded to the High Court during the course of 2016. All in all, as head of the judiciary, I'm happy with the performance of the High Court in 2015 and commend the judges in that court. I urge them to keep up the good work in 2016 and beyond. I am confident that at the current rate of performance and with the added appointments, delays and backlog in the High Court is likely to be a thing of the past. At the beginning of my address, I referred to the decision to further decentralize the High Court to all the provincial capitals, which we currently serve as circuit courts. These are Masvingo, Wange, Weru, and Butare. Due to the financial outlays that are necessary when setting up a permanent court, we will not be able to establish permanent High Court stations at all these centers in one fell swoop. What will inform us on when and where we are to set up a High Court first will include, among other considerations, the statistics coming from each province and the availability of suitable infrastructure to house the High Court. This will also determine the number of judges to be deployed to each station. Mr. Attorney, I'm also happy to report that the judiciary has readily embraced the current efforts by the executive to ease the doing of business in Zimbabwe. To this end, we are working on the modalities of establishing a standalone commercial law court as a division of the High Court to deal with commercial law matters speedily. We believe that the setting up of this court with judges dedicated to commercial law court matters will not only ease the doing of business in Zimbabwe, but will also mark the beginning of specialization in our High Court as a means of improving overall efficiency. We urge all stakeholders to assist us in realizing this vision for our country in the not too distant future. Turning to the Labour Court, like in all other courts, the number of matters filed in the Labour Court has been increasing steadily over the past 3 years. In 2013, the court received a total of 2,095 cases. In 2014, it received a total of 3,185 cases. In 2015, it received a total of 3,659 cases. These figures are inclusive of appeals, reviews, and applications. Whilst the clearance rate of the court increased, the overall backlog went up by 4% during the year under review. Each year the court is managing to clear fewer cases than it is receiving, and this scenario accounts for the increase in the backlog. I urge the senior judge and all judges of the Labour Court to double their efforts and ensure that in 2016 they complete more cases than they receive so that they start reducing the backlog. The High Court and the Magistrates Courts have managed to do so, and I'm confident that they can do the same. Turning to the Administrative Court, there was an increase of 19% in the number of cases filed in the Administrative Court during 2015. In 2014, a total of 83 cases were filed in the court. And in 2015, the number rose to 99. The court maintained its position as the court that is just enough work to justify the appointment of a single judge. It completed a total of 110 cases in 2015 as opposed to 109 in 2014. It has also managed to reduce its backlog from 31 to 26. Turning to the Magistrates' Court, during the course of the year, the performance of the regional courts countrywide was outstanding. The courts opened the year with 233 cases pending. Countrywide, the courts received a total of 3,636, giving a grand total of 3,869 cases to be determined by the courts during that year. Of these 3,869 cases, the courts completed 3,000 The court completed 3,724, closing the year with only 145 cases pending. The Eastern Division, which includes the Harare Regional Court, deserves special mention. It receives the largest number of cases due to the size of its catchment area. It managed to reduce its backlog from 134 cases to 96 cases at the close of the year. To all the regional magistrates in the Eastern Division, I say, well done, keep up the good work. The provincial courts also performed very well during the course of the year under review and managed to keep the backlog at 2,229 nationwide. There is no backlog in civil cases in the Magistrates' Court, as all cases are set down as soon as they are ready to be heard. The court received 87,536 during the course of the year. The court completed 87,182 cases during the same year. That completes my overview report on the performance of the courts. I wish to mention before concluding that the Judicial Service hosted the South and East Africa Judges Forum Annual General Meeting and Conference. Before I conclude, I wish to register my appreciation to His Excellency, the President of the Republic of Zimbabwe, Comrade Harare, for agreeing to be the guest of honor and to deliver the keynote address at the SADC conference, which we, the judiciary in Zimbabwe, hosted in August 2015. Whilst he could not attend in person, we cherish his gesture of delegating the task to the Vice President, who is also the Minister responsible for legal and parliamentary affairs, the Honorable E.D. Mnangagwa, who eloquently delivered the President's speech. I was particularly taken by the fact that His Excellency, the President, exhorted all Chief Justices present at the conference to take charge and play a leading role in the eradication of corruption within the come up with mechanisms to ensure that judicial officers remain accountable to the people. These are exhortations that, as we go into 2016, I will take very seriously. In conclusion, I wish to thank all those who were directly and indirectly involved in the organization of SAGA for a job well done. In this regard, I wish to single out Justice Makarao and their team from the JSC and thank them for the exceptional organizational feat. You did us proud. We were all thrilled to know that we had raised the bar so high in hosting the function that other jurisdictions are now thinking twice before they offer to host the 2016 AGM conference. I believe that all of us gathered here, working together, can raise the bar in matters of justice delivery to a level where other jurisdictions can only emulate. With these few remarks, I'm not sure I can talk a few remarks, I hereby declare the 2016 legal year officially open.